Legislative privileges, inhibitions, and disqualifications. Privileges: salaries, freedom from arrest, speech and debate clause. That's it. Some privileges. Let's go first to salaries. Salaries. Section 10, Article 6. The salaries of senators and members of the House of Representatives shall be determined by law. No increase in said compensation shall take effect until after the expiration of the full term of all members of the Senate and the House of Representatives approving such increase. Section 17, Article 18. Until the Congress provides otherwise, the President shall receive an annual salary of 300,000 pesos. The Vice President, the President of the Senate, and the Speaker of the House of Representatives, and the Chief Justice of the Supreme Court, 240,000 pesos each. The Senators and the members of the House of Representatives, Associate Justices of the Supreme Court, and the Chairman of the Constitutional Commissions, 204,000 pesos each, and the members of the Constitutional Commissions, 180,000 pesos each. Wow. Expiration of the full term of all members of the Senate and the House of Representatives is singular and means that the increase may only take effect upon the expiration of the terms of both houses who pass the law increasing said salary. This means that even if the House of Representatives' term has already expired but the Senate has not, the salary increase cannot yet take effect even if the increase is different from each house. From the case of Felconcept v. Matay, 1966. The prohibition also applies to the benefits of a member of the Congress will attain upon retirement. Thus, a member of Congress may not compute his retirement benefits based on a salary increase which he was not able to reach because his term has already expired before said increase took effect. Ligot v. Matay, 1974. Second privilege, privilege from arrest. A senator or member of the House of Representatives shall, in all offenses punishable by not more than 6 years of imprisonment, be privileged from arrest while the Congress is in session. That's from Section 11, Article 6. Regardless of the whereabouts of a senator or member of the House, freedom from arrest holds so long as the Congress is in session. Freedom from arrest applies not only to offenses punishable by not more than 6 years imprisonment. Preventive suspension is not a penalty. Under Order of Suspension under RA 3019, or the Anti-Graft and Corrupt Practices Act, is distinct from the power of the Congress to discipline its own members and did not exclude members of the Congress from its operation. From the case of Defensor Santiago v. Sandigan Bayan, 2001. In People v. Halosos, the Supreme Court denied the request of Congressman Halosos that he be allowed to attend legislative sessions. The denial was premised on the following. 1. Membership in the Congress does not exempt an accused from statutes and rules which apply to validly incarcerated persons. 2. One rationale behind the confinement is public self-defense. 3. It would amount to the creation of a privileged class without justification and reason. And 4. He was provided with an office in the new beloved prison. Third privilege, speech and debate clause. No member shall be questioned nor be held liable in any other place for any speech or debate in Congress or in any committee thereof. Section 11, Article 6. The members of the Senate or members of the House can still be questioned and held liable in Congress. To come under the guarantee, the speech or debate must be one made in Congress or in any committee thereof. Publication of an alleged libelous letter is not covered by the privilege. From the case of Jimenez v. Cabangbang, 1966. What is covered under this provision? Any member of the Congress says, in line of his legislative function. 1. Speeches. 2. Utterances. 3. Bills signed. 4. Votes passed. While the immunity of a member of the Congress is absolute and thus even the Supreme Court cannot discipline a lawyer senator for remarks made against the court, it does not shield said member from the authority of the Congress to discipline its own members. Defensor Santiago v. Pobre, 2009. Inhibitions and disqualifications. What are the inhibitions? 1. May not hold any other office or employment in the government during his term without forfeiting his seat, Section 13, Article 6. Incompatible office. When does it happen? The forfeiture of the seat in Congress shall be automatic upon a member's assumption of such office deemed incompatible. Thus, when a governor-elect ran for the Batasang Pambansa and won, he could not hold both offices. In the case of Adasa versus Pacana, 1985. Note that the office of the Philippine National Red Cross chairman is not a government-owned government office or an office in a government-owned or controlled corporation for the purposes of prohibition in Section 13, Article 6 in the case of Liban versus Gordon. But note that the structure of the Philippine National Red Cross is sui generis, being neither strictly private nor public in nature. Second, prohibition may not be appointed to any office created or whose emoluments were increased during the term for which he was elected. Section 13, Article 6. Forbidden office. Lain raning sa incompatible office. A forbidden office is one to which a member cannot be appointed even if he is willing to give up his seat in Congress. The effect of his resignation from Congress is the loss of his seat therein, but his disqualification for the forbidden office nevertheless remains. Third, limitation. Shall not be financially interested, directly or indirectly, in any contract with or franchise or special privilege granted by the government during his term of office. Section 14, Article 6. Fourth, shall not intervene in any matter before any office of the government where it is his pecuniary benefit or where he may be called upon to act on account of his office. Section 14, Article 6. The pork barrel system runs afoul of Section 14, Article 6 because in allowing legislators to intervene in the various phases of project implementation, a matter before another officer of government, the pork barrel renders them susceptible to taking undue advantage of their own office. Fifth, inhibition and disqualification. Cannot personally appear as counsel before any court, electoral tribunal, quasi-judicial, and administrative bodies during his term of office, provided for under Section 14, Article 6. This prohibition is absolute. Thus, when an assemblyman acting as counsel for one group of an internal dispute and a company was denied leave to intervene, the court held that his action of buying 10 stocks in order to be able to intervene in a company's dispute as a stockholder was an indirect violation of his rule and is still unconstitutional. Puyat versus De Guzman, 1982. Duty to disclose. What does he need to disclose? 1. Sal N. 2. Financial and business interest. Potential conflicts of interest. 3. Amounts paid to or expenses incurred by each member. Okay, Sal N. Section 17, Article 10. A public officer or employee shall, upon the assumption of office and as often thereafter as may be required by law, submit a declaration under oath of his assets, liabilities, and net worth. In case of the President, the Vice President, and members of the Cabinet, the Congress, the Supreme Court, Constitutional Commissions, and other constitutional officers and officers of the Armed Forces with general or flag rank, the declaration shall be disclosed to the public in a manner provided by law. When to disclose? N. 1. Within 30 days after assuming office. 2. On or before April 15 after disclosing of the calendar year. 3. Upon expiration of the term of office, resignation, or separation from office. Who must declare? 1. President. 2. VP. 3. Members of the Cabinet. 4. Members of Congress. 5. Members of the Supreme Court. 6. Members of the Constitutional Commission and other constitutional offices. 6. Officers of the Armed Forces with general or flag rank, as provided for under Article 11, Section 17. Next. Ang next nga, duty to disclose is financial and business interest. Wait. Subsection 2, Article 6, all members of the Senate and House of Representatives shall, upon assumption of office, make a full disclosure of their financial and business interest. And lastly, of the duties to expose, amounts paid to, or expenses incurred by each member, provided for under Section 20, Article 6, the records and books of accounts of the Congress shall be preserved and be open to public in accordance with law, and such books shall be audited by the Commission on Audit, which shall publish annually an itemized list of amounts paid to and expenses incurred for each member. Quorum and voting majorities. Quorum, provided for in Section 16, subsection 2, Article 6, a majority of each house shall constitute a quorum to do business, but a smaller number may adjourn from day to day and may compel the attendance of the absent members of such manner, and under such penalties and such house may provide. In computing a quorum, members who are outside the country, thus outside of each house's coercive jurisdiction, are not included. Majority, what does it mean? It shall take into consideration the number of members within the jurisdiction of the Congress, those it can order arrested for the purpose of questioning. In the case of Avellino versus Cuenco, 1949, one senator was out of the Philippines, which is not within the jurisdiction of the Senate, so that the working majority was 23 senators. There is a difference between a majority of all members of the House and the majority of the House, the latter requiring less number than the first. Therefore, an absolute majority, 12 of all the members of the Senate less than 1, constitutes a constitutional majority of the Senate for the purpose of quorum. Voting majorities. Doctrine of shifting majority. For each House of Congress to pass a bill, only the votes of the majority of those present in the session, there being a quorum, is required. Di sila ni tanan. Basta kayong majority ra, which constitutes the quorum. Exceptions to doctrines of shifting majority. Votes where requirement is based on all members of Congress, requirement is based on the entire composition of the House or Congress in its entirety, regardless of the number of members present or absent. Action, votes required, House voting, and basis. Okay. What if the Senate shall elect its president and the Speaker of the House? Votes required, majority. House voting separately, all respective members. Basis is Section 16, subsection 1, Article 6. What if? To punish for disorderly behavior and may suspend or expel, voting requirement, 2/3 of the vote. Voting separately, all respective members. Basis is Section 16, subsection 3, Article 6. What if they have to override presidential veto? Vote required, 2/3. Separate voting, the House where the bill originated votes first. Basis, Section 27, subsection 1, Article 6. What if tax exemptions ang i-vote? Majority, dili 2/3 but majority. House voting, no mention, silent siya. Basis is Section 28, subsection 4, Article 7. What if they have to elect the president? They have to vote majority, voting separately. Basis is Section 4, subsection 5 of Article 6. What if they have to confirm the appointment of the vice president? Votes required, majority. Voting separately. Basis, Section 9, Article 7. What if the Congress affirming that the President is unable to discharge the powers and duties? Votes required, 2/3. House voting, Congress. Basis, wala. Action, what if they have to revoke or extend martial law or suspend the privilege of the writ of habeas corpus? Voting needed, majority. House voting jointly, provided for under Section 18, Article 7. What if amnesty grant? Votes required, majority. Voting is silent as to which house, but it's provided in Section 19, subsection 2, Article 7. What if they have to submit a question of calling a constitutional convention to the electorate? Voting required is majority. House voting is silent, no mention, but the basis is Section 3, Article 17. What if they have to call for constitutional convention? Voting required is 2/3. House voting is silent, but the prevailing is, by default, the houses vote separately because Congress is bicameral. Basis is Section 3, Article 17. What if they have to postpone amendments as Constitutional Assembly? They have to vote three-fourths. The provision is silent. The House voting provision silent, but by default the houses vote separately because Congress is bicameral. Basis is Section 1, subsection 1 of Article 17. Other cases. What if, to determine the president's disability, votes required, 2/3 of both houses voting separately. Basis, Section 11, subsection 4, Article 7. What if, declaring a war or a state of war, 2/3 of both houses in joint session voting separately? Basis is Section 23, subsection 1, Article 6. What if ang validity of treaty or international agreement? Voting needed is 2/3 members of the Senate. Ang basis is Section 21, Article 7. Discipline of members. Each house may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 of all its members, suspend or expel a member. A penalty of suspension, when imposed, shall not exceed 60 days. From Section 16, subsection 3, Article 6. Each house may punish its members for disorderly behavior, and with the concurrence of 2/3 of all its members, with said effect. Ang mnemonic is said effect, where suspension or expulsion. Ang other measures are deletion of unparliamentary remarks from the record. Ang effect is fine, imprisonment, or censure. The suspension contemplated in the Constitution is different from the suspension prescribed in the Anti-Graft and Corrupt Practices. The former is punitive in nature, while the latter is preventive. From the case of Defensor Santiago versus Sandigan Bayan, 1995. The determination of Congress when it comes to disciplining its members is respected by the court. As such, the Supreme Court does not have the power to compel Congress to reinstate a member who has been expelled by it. The case of Alejandrino versus Quezon, 1924. Immunity for speech given to a member of Congress is not a bar to the power of the Congress to discipline its members. The case of Osmeña versus Pindaton, 1960. Process of lawmaking. Requirements as to bills. As to titles of bills. So may buhaton sa Congress as to titles of bills. Provided for under Section 26, Article 6, every bill passed by the Congress shall embrace only one subject, which shall be expressed in the title thereof. Requisites under one subject, one title rule. 1. To prevent hodgepodge, log rolling, or the smuggling of riders, that is, any act containing several subjects dealing with unrelated matters presenting diverse interests. 2. To prevent surprise or fraud upon the legislature. 3. To fairly appraise the people or the subjects of legislation that are being considered in order that they may have the opportunity for being heard thereon, by petition or otherwise, if they should so desire. 4. But the title need not to be a complete catalogue of a bill. In any case, a title must not be so uncertain that the average person reading it would not be informed of the purpose of the enactment. And lastly, the title of the bill is controlling over the text, from the case of De La Cruz versus Paras, 1986. What are the requirements as to certain laws? The lain requirement per appropriation law, lain requirement procedure is procedure and the passage of bills is also not. You also have to read that.